Welcome to the Find Your Exit podcast, where the leading authority on buying, selling, fixing, and growing companies, Michelle Seiler Tucker, is dedicated to helping you find the path to retire rich and move on to your next adventure by exiting your business for the desired dream price you deserve. Get ready to find your exit with your host, Michelle Seiler Tucker.
Welcome to another episode of Find Your Exit. Thank you for joining us. I am so excited to welcome a true professional, Maria Crimi Speth. Maria Crimi Speth has been practicing in the area of intellectual property, internet law, and commercial litigation, representing clients throughout the United States, litigating for over 30 years. She practices in the state and federal courts of Arizona and New York, as well as the United States Courts of Appeal for 6 different circuits and the Supreme Court. She is the author of 2 published books, Protect Your Writings, a legal guide for authors, and Apple versus Samsung. That should be an interesting read. The balance between patent rights and the free market. She's been named Best Lawyer in America, Copyright and Trademark Law since 2015, and was selected to Super Lawyers from 2016 to 2019. Best Lawyers named her 2019 Technology Lawyer of the Year. Maria has numerous published and precedent-setting cases. All right, so welcome to the show, Maria. It's an absolute pleasure to have you on. You have quite the credentials, practicing law for 30 years and being named top best attorney. That's amazing. How did you get started?
Thanks, Michelle. I'm so happy to be here. I've always had an interest in intellectual property law ever since I was in law school. It's just been a fascinating topic to me. It's just one of those areas of the law that is ever changing and always keeping me interested. So I just love it. Yeah, it's great.
And I think you've done quite well at it because, I think the most important thing to business owners is protecting their IP, their intellectual property. Because I specialize in doing mergers and acquisitions, buying, selling, fixing, growing businesses. And I can literally sell a company for 2 times, 3 times, 4 times more times EBITDA if they have IP, if they're well branded. We talked about this before, but the Coca-Cola brand alone is worth $89 billion. The Apple brand alone is worth over $100 billion. So I call it 5 pillars of IP, and the first pillar of IP is branding. How do clients go about protecting their intellectual property, their company name, their slogan, their logo, everything that makes, that goes into that branding?
Yeah, and it's not just brand. As you said, it's more than that. Intellectual property is actually broken down into 4 categories. Mm-hmm. It's trademarks, copyrights, mm-hmm. trade secrets, and patents. Mm-hmm. And so each one of those, I'll just quickly, go over what they are. Your trademark is your branding, right? That's going to be your slogans and your brands and what the customer identifies as you, when as the source. Your copyrights is your underlying content. And not all businesses have copyrights. Some are more traditional businesses that have traditional services, but a lot of companies have a lot of copyrights, like any software-based company has copyrights. So there's trademarks, copyrights, trade secrets. That's going to be your proprietary information that you keep secret, that the back end stuff that the world doesn't see. Right. And then patents, which is if you've got an invention that is so unique and so novel that you can actually protect and get a monopoly on it. So those are going to be your 4 areas. And as you mentioned, Michelle, this is so important. The value of a business is very, very much tied to the intellectual property that it has. I mean, if you think about, if we added up all of the assets of the business and we put a number on that, and then we look at the value of the business itself, there's always this large gap between what the assets are worth, the tangible assets, mm-hmm. and what the business is worth. And a great deal of that gap is the intangible property.
Absolutely. And like we said, the more well-branded a company is, as long as they're still doing well, the higher price they're going to be able to dictate. So let's take your 4 and break it down. I said 5 because I also add into IP databases, because databases are huge. Like WhatsApp, Facebook paid $19 billion for WhatsApp, and WhatsApp was hemorrhaging money, but they had 1 billion users. So Facebook knew they could ROI, they knew they could monetize on the sale of that business. And then the other thing I put into my IP is contracts. Anytime you have contracts with your clients, contracts with manufacturers, vendors, maybe contracts that somebody else can't get, as somebody's doing business with Shell Oil, and those contracts, there's a moratorium on those contracts, that adds huge value, and buyers are willing to pay more money for that, as long as those contracts are transferable. So that's why
Totally
I said
agree
the
with that.
5 pillars. Yeah.
Yeah.
But
I totally agree with that. And I think your pillars are correct. And the only reason I say 4 is because the database is going to be part of copyrights. So it's from a legal perspective, it's not separate. From a financial perspective, you're absolutely right. It's its own pillar. And then contracts is typically going to be either your, well, actually, contracts are kind of on their own, aren't they?
They are. They are.
And they're very valuable and very important.
And yes, and it's shocking to me that I will tell you probably about, I've done thousands of transactions over 20 years, and I would tell you maybe only 1% actually have that language transferable in their contracts. Most business owners never have a transferable clause in their contracts, and it can kill a deal because 99.9% of all sales are asset sales, not stock sales. So it's a big issue when those contracts are not transferable.
Absolutely. And even if there's a no assignment clause, there should be an exception to the no assignment clause in the case where most of the assets of the company are being sold. You're
Absolutely.
100% correct. Mm-hmm.
So let's take your 4 and break that down and tell our listeners how they can protect each one.
Sure. Let's start with brands. We'll start with trademarks.
Sure.
And I think it's several steps in the trademark process. The first step is going to be to pick an unusual trademark. So there's this temptation to pick a trademark that purely describes what you do. Right. And those trademarks are actually, from a legal perspective, not the strongest trademarks. Now, I don't know from a marketing perspective, I'm not a marketing person, but from a legal perspective, they don't have the same level of strength. And I like to use eBay as an example. So if eBay had decided to call its company Online Auction, that would not have been as strong of a brand as eBay was. And when they first called themselves eBay, people didn't know, well, what's an eBay, right? But we learned it, and they created that connection in the minds of the customer between eBay and an online marketplace. And they, in the beginning, would use a tagline to sort of bridge that gap between what's eBay, it's an online marketplace, and so that tagline would help people to know what it is.
Right.
And so number 1 is pick an unusual brand. The more unusual the brand, the higher level of protection you will get.
Well, what about, let me ask you one quick question. What about Amazon? Amazon is not really unusual, right?
It is, in that so we break trademarks down into 4 different categories, and it falls into what we call an arbitrary category. So the highest level of protection is fanciful, which is your made up words like eBay, like Exxon, Xerox. Also arbitrary trademarks. And an arbitrary trademark is like Apple in connection with computers, or Amazon in connection with a marketplace. So those are words, and in Amazon's case, it's a geographic region, but it wasn't otherwise associated with a marketplace. So they created that connection. The next category after arbitrary and fanciful is suggestive. A suggestive trademark tells us something about the brand, about the underlying products and services, but it doesn't come right out and describe it. I like to use the example Greyhound in connection with buses, because a Greyhound, if you think of Greyhound, you'll think it's fast, you'll think it's sleek, it's graceful. So those are suggestions that Greyhound likes to correlate to their brand. Right? So there's some correlation, but if I said to you, if you didn't already know it, and I said to you that my brand was Greyhound, you wouldn't know that I had a bus company. Correct. So that's a suggestive trademark. A descriptive trademark is the ones that I'm telling you to avoid. That's something that describes your goods and services. And then the 4th category is not really a trademark at all. It's generic. I've created a new hair wash and I want to call it the shampoo. I can do that, but I can't stop you from calling yours shampoo. It's what everybody calls hair wash. So that's generic.
Gotcha. Okay. And so I'm good because I'm Seiler Tucker Inc., which is my name. So I'm not going to have any issue with trademark at all. And then in my slogan, we say the business authorities on buying, selling, fixing, growing businesses.
So your slogan helps people to understand what you do, which is a great way to use a slogan. And then your brand is unusual.
Correct.
That's very good.
Correct. But like, many business owners, I made a mistake too. I had a name called Capital and everybody thought I was a bank. Plus we were spammed all the time. So it's really important to hire an expert, to hire an attorney to make sure you sort all this out and make sure you get not just a local trademark, but a federal trademark as well.
Yes. So once you pick the name, the next thing you want to do is you want to search it to make sure that it's available, to make sure that you're not infringing on somebody else's trademark. And I recommend that people do the search themselves to begin with, but then ultimately they hire a professional to do a professional search.
Yeah.
Assuming it's available, you'll want to grab up the domain name if it's if it's available and if that's important to your business model. And then finally, your last step is going to be to register the trademark with the United States Patent and Trademark Office. And I don't recommend that you try to do that yourself. That can be a tricky process. I would have you hire somebody for that. It's something I do, but anybody who knows how to do that is fine. But it's important because it gives you rights throughout the United States. You're acquiring trademark rights in your own region geographically as you're using it, but those rights then get expanded throughout the entire United States once you file a federal registration.
How long does that trademark last?
Forever, as long as you renew it. So Coca-Cola has had the Coca-Cola trademark, I think, for close to 100 years. Between the 5th and 6th year of registration, you have to file something called a statement of use. And in the 10th year, you have to file a renewal. And then every 10 years after you file a renewal. But as long as you do that, it lasts forever.
Gotcha. So have you seen where like companies will get in trouble years later because their brand name is too generic? Like for instance, do you remember Cookie Bouquet?
Mm-hmm.
Cookie Bouquet had to drop the name Cookie Bouquet, right? Because it was too common. And they had to select it. I forget the name that they changed to. But why was that? Is that because it was just too of a generic name and somebody was fighting them about that?
Yeah, I think on that one it had to do with a dispute, but I'm not particularly familiar with that one. But I know many others where companies were in business 3, 4, 5 years and suddenly and they've put a lot of marketing dollars into it, and suddenly they'll get a cease and desist letter that says this is a federally registered trademark, you can't be using it. And that is not a good thing. It is not a good thing to have to go back to the drawing board after you've already started to create a brand and you've already gotten traction. So do it early, check it early.
Yeah, and probably check it often. And then the other thing too is like when you start searching for names for other products, like for instance, we just started a membership called Club CEOs. Well, I was on the phone with somebody the other day and I said, did you trademark that? And I'm like, oh, I forgot. And I'm the expert in this stuff and I forgot. But yeah, so now my attorney is working on trademarking that now. But it's important if you're going to take anything like a Club CEOs or any type of membership or course or something like that and get that trademarked, correct? Because you could be spending all that money in marketing Club CEOs and then I have to take it down.
Yes. From a sequencing point of view, before you put any substantial or significant dollars into marketing a brand, you should search it first and register it first. That's the order that should go in.
Now, do you have to do that with a book? Because I know that unless it's a series, you can't trademark the name of the book. However, you still should do your research because you want to make sure you're not infringing on somebody else's trademark. Like you don't want to name somebody Rich Dad. You don't want to name something Rich Dad, right? Or Chicken Soup for the Soul, or, you're going to be very careful.
Exactly. So book titles, as you said, book titles cannot be protected, but they can infringe other trademarks, right? So you should not call your book title something that is already taken as a brand, especially if that brand is related in some way to book series. Mm-hmm,
yeah, initially before we named my book Exit Rich, what was Sharon Lecter, who wrote Rich Dad Poor Dad, we were going to name it The Prophet Speak. And I go, wait a minute, The Prophet. Well, The Prophet is Marcus Lemonis on CNBC. And the people I was working with at the time were like, oh, it's fine, it's fine, it's fine. I'm like, I guarantee you that is not fine. With an attorney. And I did, and my attorney's like, no. And CNBC has a lot of money. So you need to change that.
Yeah. You know what's a good test is sort of like the gut check test, is to say if it was flipped, if that was my brand and somebody else started using this brand, would it bother me? And if the answer is yes, then it's probably true the other way around.
Right.
So if you're not sure if the other side is going to care, or the other party is going to care if you start using that trademark, try to put yourself in their shoes and wonder what would you feel if it were you? Would you be like, oh, that doesn't matter, it's pretty different? Or would you think, no, that's kind of similar, that bothers me?
Yeah, and I think it's very important to slow down, because us entrepreneurs, we come up with an idea at 3:00 in the morning. We want to get up at 3:00 in the morning, go get that domain and act on it.
Yes.
And, some of us have 150, 300 domains. I do. And so I'm always come up with different things. And then I'm like, slow down, go see, go look, make sure it's available. So we just have to slow down as entrepreneurs sometimes.
True.
So we talked about your 4 pillars. We talked about the 1, branding, and how to protect that. Any other tips as far as that one goes?
Think we talked about what we need to talk about. Oh, I know what we didn't talk about on trademarks. A very common question I get on trademarks is, should I register just the words, or should I register a stylized or a logo version of the words? So if we use Coca-Cola as an example, should I register Coca-Cola in just typed format, just standard, or should I register it in that script that we all can see in our minds? And my answer is, do both. And if your budget does not allow you to do both, then just do the words, because your stylization and your font and your color scheme may change over the years. They get freshened, they get, renewed. And so that is probably not the one that's going to last a really, really long time. It's going to be the words that are going to last a long time. And when that 5-year renewal comes and that 10-year renewal comes, if you're not using it in exactly the same form anymore, then you won't be able to renew it. So by all means, register your stylization if you have it, but don't fail to register the standard character mark.
And the name and the slogan is very important to register, right?
Yes.
Okay. And then what about if you have different, I guess, slogans or sayings that you use for processes? Like I have the 6 Ps, the Seiler Tucker 6 Ps, and we are getting that trademarked right now, and we use a TM after that. Is that correct protocol?
Yeah, so it's always correct protocol to use the TM anytime you claim something as a trademark. You don't have to have something filed to use the TM. You just have to claim a trademark. Okay. You should not use the R in the circle until you actually have a registered trademark back. It's not enough that it's in process. It's you've gotten it back, then you should change it to the R in the circle.
Okay.
The other thing that you'll want to be careful about with what you just described is you can't register as a trademark the name of a process. It has to still be a brand. So as you're presenting it to the trademark office, you want to be clear in both your proof of use and in your wording that this is a source identifier, this is a brand identifier, and not just the name of a process.
Yes, and I said process. What I really meant was brand, because the 6 Ps is a brand. The Seiler Tucker GPS exit model is a brand, and we're trademarking that as well.
Exactly.
So, but for everybody listening, you can put that TM, and that helps protect that you're claiming that.
Exactly.
Okay, great.
Exactly.
Great. All right, so we're good with number 1, right?
Trademarks, we're good.
So what's number 2 for you?
Copyrights.
Copyrights.
So your copyrights are going to protect your content and your databases, right? So we'll talk about databases along with content. So any content that you create or that is created for you is copyright protected. So some examples would be certainly a book, the interior of a book, the wording of the book. Maybe your business models, your marketing pieces, the content that's on your website. If you're in the photography world, certainly your photographs. If you're in the graphics world, your graphic design. All of that is all protected by copyright. And the copyright's automatic. As soon as you create it, it's owned, and you have copyright protection. But in order to get an additional level of protection, you'll want to register it with the Copyright Office, and that's copyright.gov. And by doing that, you're getting additional remedies and available to you that you would not otherwise have. And that's important because if somebody infringes your copyright, you don't want to have to file a lawsuit, and you don't want it to be difficult to stop them. And if you have a registration, it's much easier to stop them. So I highly recommend that.
The copyright in your book, obviously you register that, but what about the copyright, the copy that's on your website? You have to register that as well?
You don't have to register it. So the Copyright Office is about to change their rules in a good way, and that is for blogs. So for your website, it depends. It depends on the industry you're in, whether you think it's worth registering. But if you're doing a blog, it is a good idea to register the copyright. And the dilemma used to be that you're always adding to it and you're always changing it. Now, copyrights are not expensive to register. It's only a $70 filing fee, and that one you can do yourself. But you don't want to have to constantly do it every time you write a new blog, right?
Right.
So they just changed the law, and it's going to go into effect, I want to say next month, or I believe it's next month it's going into effect, that you can register your blog for the whole year and cover all of the additions to it. So once a year, it's going to cover everything that you added to your blog. So I do recommend that, using that and getting your blog protected if you have a blog.
I love that, because we write probably about 12 blogs a week.
Right.
A week. So if we register one time, it will cover all of our blogs for the whole year.
That's what they're
And
going to start doing.
that's a $70 registration fee?
I don't know if they're going to keep it the same price or if they're going to up the price a little bit, but it won't be much more than that.
And that we can do on our own, right?
Yes.
I love that. See, that's great advice that most people don't realize.
Yeah.
Okay. Yeah. So what else should we get copywriting? So the content on our website, our blogs, our books. What else?
And you mentioned the database. Brilliant.
Database.
Brilliant.
Yeah.
Brilliant. We do not want to forget about databases. So a compilation is protected by copyright. And a lot of people don't realize that. They know their database is valuable. Everybody knows their database is valuable. And they think it's valuable in part because it's a trade secret, and it is. It's because you're not going to let anybody have that database, right? But it's also considered to be a compilation. And so you've got two ways to, I guess, two overlapping coverages on your database. And as you pointed out, that database can be incredibly valuable.
Yes, especially, I mean, the more users you have, as long as they're active, then the more valuable it is, which is why Facebook was willing to pay so much for WhatsApp.
Exactly.
So it's
exactly. And you don't want to put it out there. You want to keep it a trade secret.
Right.
But just know that there are some protections on copyright. If somebody did get their hands on it and used it, in addition to your violation of trade secrets, you would also have a violation of your copyrights.
So how would they register the copyright of their database?
So you won't want to register the copyright on that one, because by registering it, you would make it public, and you probably don't want to make it public. So that's going to be
clients would want that.
That's going to be a copyright that you're going to keep without registration.
Gotcha. But you created it, so you own that copyright.
Yes.
Okay.
Oh, let's talk about ownership for a minute, because I don't want to skip this. This is important.
Yes, because I was about to ask you about blogs. If I had employees writing blogs who work for me, or interns writing blogs, who owns that blog?
Yeah. So copyrights are funny, right? And I'm going to use the tangible world example as the difference. So Michelle, if I hired you to build a cabinet for me, and you say, I want $200 for the cabinet, and you go into your woodworking workshop, and you build me a cabinet, and I pay you the $200, and you give me the cabinet, there's no doubt that I own that cabinet. I paid for it. I bought it. It's mine.
Right.
On the other hand, if I hire you to create, let's say, some content like a blog, and you're not my employee, you're an independent contractor, and I pay you the same $250 and you give me the content, I do not own it. You own it. And so if you're in an independent contractor situation, you're hiring independent contractors to create anything for you, develop software, create content, write blogs, take photographs. In all of those situations,
create logos.
Create logos. In all of those situations, the independent contractor owns the copyright, unless you have a written agreement that specifically says that they are transferring the copyright to you.
Okay.
Now, you mentioned employees. When the person doing the writing is an actual employee, you're actually paying them a paycheck, you're withholding taxes, it's a classic employment relationship. In that case, you own what your employees create. But in the independent contractor situation, you do not, and it is critical for you to have a written contract.
So where can we get that contract? Where's the easiest place to get that contract? Because I guarantee you that most business owners have independent contractors, interns that write stuff, create logos, create copy, etc.
So I'm going to call it a clause rather than calling it a contract, because you should have a robust contract with them that talks about what are the deliverables, what are you paying them, and obviously there isn't a standard contract for all that. But within that contract, there should be a clause, and that's quite standard. It should be a work for hire / assignment clause. And work for hire means that if from the moment that they created it becomes yours, and if it doesn't fall into a classic work for hire situation, then you're also having an assignment. So where could you get that? I would look online for work for hire / assignment contract template. Or if somebody wants to email me, I can get you a very, very basic standard form. But my disclaimer is, my disclaimer is that that shouldn't be the only contract you have with them. It should just be part of the contract you have with them. It's just language that's important to have in it. And if the service provider is giving you a contract, look for that language. Because here's what happens. Okay, I hire a software developer. They give me a software development agreement. If that agreement is silent on ownership, they own it. So what I'm looking for is I'm looking in that contract for language that specifically says that they are transferring or assigning to me the copyright in what they create for me.
Wow, that's a great point. I mean, I just hired a developer to develop some of our courses on build to sell. I'm going to go back and look at the agreement to make sure I own it before I pay the final balance.
Exactly, because that's the time
to you and have you look at it.
That's the time to negotiate it, is before you pay the final balance. That's right.
Always, yeah. These are great tips. Great tips. Like I said, you don't know what you don't know. So, the great tips. Yeah. Anything else on ownership or copyright, or?
That's about it on the copyright side.
Okay. So number 3
was trade secrets or proprietary information, and that's really simple from a legal perspective. That's really a matter of sharing information that you consider to be proprietary on a need-to-know basis, and then getting non-disclosure agreements from people when you do share it. If you follow those 2 rules, you're fine. There's nothing to register. There's nothing to do other than don't share it with people who don't need to have it. And when you do have to share it with them, get them to sign agreements that say that they're going to keep it confidential.
But what about employees or independent contractors who work with you, and maybe you have those trade secrets in your business? Do they have to sign that disclosure agreement? Is that part of their employment agreement or their independent contractor agreement?
Yeah, I don't want to say have to, but it's going to be much, much harder to protect your trade secrets if you didn't have a written agreement that said it was confidential. Now, if you verbally express to your employees and to your independent contractors that the information is confidential, I have successfully litigated that issue, but it's going to make it so much harder to win than if you just have it in writing. So I would highly recommend that you have it in writing with anyone, whether even employees, but definitely independent contractors, that says that, that they will keep confidential information confidential and identify what's confidential. The other thing I do is I've spent years litigating over the issue of what's confidential and what isn't. So people put in place non-disclosure agreements and then never identify what's confidential. And so their employees or their independent contractors don't know whether they're supposed to keep something confidential. You always want to mark it confidential. You always want to let people know, hey, this is proprietary. Don't share this.
Okay. Yeah, I mean, and what we do, obviously, selling companies, everything's confidential.
Absolutely.
We have people, we have business owners' financials. We have all their information. It's all confidential.
Michelle, I want to address something about that, about what you do. So I have worked with quite a few M&A attorneys, merger and acquisition attorneys, who are incredibly competent at what they do, but frankly don't know a thing about intellectual property. Right. And so one thing I would caution people, if you are purchasing a company, if you're selling one too, but especially if you're purchasing a company, it is a really good idea to have an intellectual property attorney involved to be looking at that paperwork and those contracts. Because I litigate them after the fact, I've seen cases where really high-level attorneys in really good firms were involved, and the paperwork didn't properly transfer or didn't properly trace the chain of title of intellectual property. And somebody who purchased something from the company got something, they didn't get what they thought they got. And I'll go back to the example of the ownership that we were just talking about. I once had a company where the sale was a multi-million-dollar sale. And what the buyer was buying was, amongst other things, was a series of very valuable audio recordings that were trainings that were doing very well and were marketed very well. What nobody really paid attention to is who owned the audio recordings. The company who sold the assets said that they owned them, but it turns out that they never had the proper work for hire agreement from the person who created the recordings. And so they sold something they didn't own, the buyer bought something they didn't own, and then the real owner surfaced later. And it was honestly a dream for somebody like me, but terrible for the people involved. Wow. So be really careful about that. And I said, if somebody had called an IP attorney during this very significant transaction, this would have never happened.
Yeah, I mean, that's a great point. Fortunately, all the transactions that we've done over the last 20 years, we've never had an issue like that, knock on wood, because we do work with firms who do nothing else but M&A transactions all over the country. And they have an IP department, they have an accounting department, they have legal department all under one roof. And us as M&A advisors, I've been through enough transactions. I know what to ask for and what to look for. I would have asked, where's the paperwork showing that you own this? Just like I asked, where's the contracts? Where's the transferability? Where's all of this information? But you are absolutely right. And I think that's good advice for anybody who's not working with me. You should be, but if you're not, make sure you hire an IP attorney, because again, you don't know what you don't know. And so what ended up happening in that? Just brief synopsis. What?
2-3 years of litigation and finally a settlement.
Wow.
A lot of money spent.
Wow. So you got to be very careful with all of that. You're right. I mean, it could be just a disaster, a mess. And but there's reps and warranties. So I would have thought that the seller would have really had to give some of that money back.
Right. That was part of the issue.
A clawback because of reps and warranties, that they own everything they say they own.
Absolutely. One of the issues was that the seller had unwittingly breached their own reps and warranties, but they didn't know it. They thought they owned it.
Yeah. See, that's the thing. You don't know what you don't know.
Don't know what you don't know. That's right.
Gotta hire the experts. Gotta hire people with the core competencies that you don't have.
Yeah.
All right. So let's get into. Are we in number 4?
Oh, 4 was patents.
Okay.
And that's obviously, if you've got a business that has inventions, you want to be talking to a patent attorney. Don't even try to mess with. I only do patent litigation,
okay.
And I do licensing, but I won't do the filings. You really want somebody who's really has a lot of experience doing them. So yeah, identify in your business. Does your business do something? Has it created either a device or possibly a process, although that can be more difficult, that is so novel and so unique that it's entitled to patent protection, because that can really, really increase the value of your business.
Yeah, and like you said, you got to follow that along and make sure who owns the patents, because typically it's not in that corporation's name. It's typically in another corporation's name or in that person's name, which is not a good idea.
Right.
But yeah, we just sold a company that had 18 patents.
Nice.
And it's a huge value driver. So talk to us about patenting processes, because you can't really patent a process, right?
Well, I wouldn't say you can't. It's gotten much more difficult to do.
Okay.
Business process is one of the areas of patents, but there was a Supreme Court case called Alice, and the Supreme Court very much narrowed, and it's difficult to get. So I think I would sort of leave it at, if you're thinking about, if you think that you have a process that's unique enough to patent, I would recommend that you not only hire a patent attorney, but that you hire one that has dealt with process patents before and knows how to deal with process patents, and that it's going to be straight with you. That because really the best patent attorneys will tell you, you're not going to get a patent on this, or if you do, it's going to be so narrow, it's not going to be worth it. right? So you want somebody who's going to be straight with you about that.
Yeah, I didn't think you could. I thought it was. Well, I thought that there was some glimmer of hope, but I heard that it's very, very, very difficult to do and
It
extremely
is.
expensive.
It
Yeah.
is. It is. That is
I
true.
wonder if McDonald's patent their process.
No, I don't know of any that they have.
Yeah.
Certainly not any main processes. They might have some minor ones that we don't know
Because when I
about.
think
But
of process, I think of McDonald's because you can go to China, you can go to Russia, you're going to get the same experience. It might look a little different in China than it does in the US, but you're going to get the same level of quality and the same level of experience because the process is the same.
yeah,
You know?
that overall broad process is not going to be patentable.
It's got to be a
When
very narrow process.
it would have to be something very, very narrow.
Right,
Correct.
right. Okay, great. Anything that we've left out as far as processes, trademarks, copyrights, databases that you can think of?
Nothing that I can think of.
I love the story that you gave us earlier. What's some of the biggest mistakes you've seen business owners make not protecting their IP?
So I see I see so many. Maybe because I've got the merger and acquisition topic on my mind, and that's the
Because
topic
you see
of
exit rich, it's a
yeah, and you alluded to it earlier. It's not a huge mistake, but it can end up being a problem. So a lot of times people will put some intellectual property in their own personal name, whether it's a patent or the trademark, and then they'll just not have a license agreement or anything in writing between themselves and their company, right? So the company is going along and the company is using the trademark and the company is using the patent, but the patent and the trademark are owned by the individual, right? And people, and a lot of times the individual says, well, I love that because I can sell the company and I still own the trademark. Or I still own the patent. And I think the mistake that they make is any savvy buyer is going to be like, no, you've got to put those together. Right. Or they've got a holding company, and it's not a mistake to have a holding company, so don't get me wrong, but they've got a holding company that holds all the intellectual property, and then they've got an operating company that operates. That is actually a fantastic way to do it. But when you sell it, you need to sell both. You need to sell the assets from both. You're not just going to sell nobody's going to buy nobody who knows what they're doing is going to buy the operating company if it doesn't own the asset.
Well, and and my firm won't even take a client on to sell their business. We won't enter into the engagement unless we get all the IP, unless the seller's willing to turn over all that. Because if they're not, then that's a big, huge red flag. Because the seller's going to go out and compete. And I've seen it happen, not with us, because we protect our buyers, but I've seen it happen time and time again, where the sellers kept the domain name, the seller kept the phone number, the seller kept, a trademark. They kept something because their whole intention was to go out and compete. And we don't do that. We make sure that all IP is included in the beginning of our engagement. If it's not, then we just move on and we won't work with that client because we're not going to set a buyer up for failure.
Perfect. And that's so I think that's very important. The other mistake we already talked about, the by far the biggest mistake that I see people make is, even in very sophisticated companies, is assuming that they own all of the intellectual property that they paid for, and without having a work for hire agreement. And even when you have employees, it is true that you own what your employee creates, but I would still have the belt and suspenders, and I would have that employee sign an agreement. Because what if it's outside the scope of their employment? Or what if they argue that it's outside the scope of their employment? So yes, I own everything my employees do within the course and scope of their employment, but I don't need them arguing that, oh, I did this on the side and it's not yours, right? So I want a good, strong contract that covers everything they do. Yeah. And so that would be another mistake I see all the time, is people just don't put contracts in place. And in the IP world, they're just critical.
Yeah, you need a paper trail. You need an absolute paper trail, and spend the money up
Absolutely.
front so you're not spending more money later.
Absolutely. And isn't that the key mistake right there, is an ounce of prevention is worth a pound of cure. I mean, pay for the ounce of prevention. And some other mistakes that I see often are people just thinking that it's really super expensive to protect their intellectual property, and so then they just don't do it. Or they just don't think about it. They get busy in their business. Their business, like you said, we go fast, and our business is rocking and rolling, and everything's growing very quickly. And then a lot of times they'll have to go back and rebuild the foundation afterwards, and it's a little bit more difficult to do. Yeah. So to not do it early would be a mistake. That I would say.
I agree 1,000%. Now, what happens when they put a trademark or the patent or something like that in their personal name versus a corporation name? And let's say there's a lawsuit that happens. Doesn't that kind of pierce the corporate veil? And they
If you,
go after their personal assets now?
yeah, so if you don't do it right, you are absolutely correct. If you wanted to own the trademark and license it to the company, you can do that without subjecting yourself to any liability, but you need to have a written license agreement between you and the company that says that you're licensing it to the company. Also, but you're still going to have some liability from the perspective of, let's say the trademark infringes somebody's trademark, then I'm going to sue the trademark owner, right? So if somebody says, well, I want to keep the trademark in my name, I'm like, that's great. That's who the litigators are going to go after if they have a problem with the trademark.
So it defeats the purpose of having a corporate entity to protect your personal assets.
Yeah, it's not the best idea. I mean, I think a holding company is a good idea, but keeping it in your personal name is typically not a very good idea.
What about in a trust? What's your thoughts about that?
I still would I would have the trust have an LLC. I wouldn't just use the trust as the barrier. I would have the trust have an LLC, and then the LLC be the holding company, and the holding company license it to the operating company. And by the way, that structure, I would only recommend that structure if the operating company is in a field that is more of a risky field. It is not necessary if you're not in a risky field. It's an overly complicated arrangement in many cases. In some cases, it's a really good idea. It depends on what your business model is.
Do you represent specific industries, or are you industry agnostic?
I represent a lot of different industries. The one thing that almost all of my clients have in common is that their assets are heavily intellectual property, but in lots of different industries.
Gotcha. That's okay. And so I heard you talk on I heard you talk at CEO Space about being in a meeting and then getting concepts and getting ideas and making sure you protect stuff. What exactly were you talking about there? I mean, you were, it was like drinking from a fire hose when you were talking, so I was trying to get all the points.
Yeah.
Do you remember do you know what I'm talking about?
I think I know what you're talking about. We were talking about virtual meetings.
Yes,
and the
yes,
unusual situation that we have. I mean, I'm going to use this as an example right now. So if I were just talking to you and nobody was recording anything, then when as soon as I spoke the words, they'd be gone, in the sense of they're not fixed in a tangible form, and so there's no copyright on them.
Right.
But because we're recording this, because you're recording this, there is now a copyright on this particular podcast, and you own it. I didn't do what I tell my clients to do. I didn't get a written agreement that said that I would own whatever I created during this podcast. So it's yours now. And so virtual meetings are interesting. If you're putting content out there that you care about, in a sense that you don't want somebody else to own it, then what you're going to want to do is you're going to want to get a written agreement that says, hey, let's be clear that I was a guest on your podcast, but I want to own the content, if that were the case. Now, I didn't care here. I don't, this content, I'll just recreate it over and over again, so I don't need to own this particular podcast, and I'm happy for you to own it. But typically, or sometimes I should say, people do care about that. And if they care about that, they're going to want to get an agreement.
Give us like an example of where that would really apply, if you can.
I don't know. I think it just depends on the industry. I think that
because I think that's such a good point, because everything's virtual now.
Everything's virtual, right?
Meetings, and most of it is being recorded. I don't think I ever have a call that's not recorded anymore.
Right, exactly. So I think here's where it might really matter. So I don't make a living speaking on this topic. I speak on this topic to get clients, right? As business development. I make a living being a lawyer.
Right.
If I made a living on this topic, I probably would care a lot more about ownership of this podcast, because I wouldn't want you having my own content competing against my own content on the internet. So if I was selling a podcast that had this content, gotcha, then I would want to have an arrangement with you that said, look, you're not going to take the podcast and compete with me. That's not my business model, so it doesn't matter to me, but it might matter to some people.
That might matter to me when I'm giving some trade secrets away on other people's podcasts.
Well, don't give trade secrets away on podcasts.
Number one rule.
Yeah,
So
number one rule.
you were also voted technology lawyer. What was it? Technology Lawyer of the Year in 2019.
Correct.
Tell us about that. And
Well, that is just a peer-to-peer review and a peer-to-peer voting system where you have to get nominated by someone else who's not in your law firm, who's an attorney, and then there's a voting process. And so it was just a vote, and I think it's a result of me just doing a lot of work for tech companies. A lot of my clients are software developers and tech companies.
okay, great. Any other tips that you have for our listeners of how to protect their intellectual property and not end up with blunders, I like to call them?
You did such a nice job, Michelle, with your questions. I feel like you covered everything. I can't think of anything we didn't cover that's important for your listeners to know.
Okay. Just early on, get advice, seek expert opinion, expert advice, and put in your foundation ahead of time, right?
Yes. Lay that foundation ahead of time.
Right.
Absolutely.
So
Absolutely.
what were you like as a little girl? Were you always wanting to be an attorney?
No, I wanted to be a spy.
A spy.
I wanted to be a spy. That was my thing for a long time. So it's funny that you asked that question because this is what I thought you were going to say. We would just on one of my, I think it's a Facebook group. Yes, it is. It's a Facebook group. Somebody posted about how many of us women, when we were young and we were in school, got really bad grades in conduct because we didn't stop talking in the class. And I was like, that was me. And sort of the lesson was, young ladies who get bad grades in conduct often end up being powerful in business. So
oh wow.
I'm gonna bet, Michelle, you probably got bad grades in conduct too.
I did. How did you know that?
Because you're a powerful businesswoman now.
I was a very unique child. I was, I didn't play with toys at all. I never played with dolls. I always just walked around with a notebook and a pen and asked everybody I came in contact with a million questions.
And that's still what you're doing.
I know. My mom always thought I was going to be Barbara Walters. But yeah, because when I started working with Tracy to do my podcast, I'm like, I don't know, Tracy, I don't know if I can ask questions. Because Michelle, trust me, you can ask questions.
You can ask
because that's what I do with my clients all day long. I ask them questions about their business.
Exactly.
So how can our listeners get a hold of you?
I'm sorry?
How can they find you?
How can they find me? Okay, so my email address or website, which one's better?
Probably a website, I think.
A website? Our website is jburgwilk.com. It's JABURGWILK.com. And so if you go to the intellectual property section of our website, you'll find all kinds of articles about some of the topics that we talked about today.
And you own it all, right?
Absolutely. Absolutely. Not me personally, my firm, but that's okay with me because I own the firm. So that works.
So what's next for you, Maria? Any big plans? What's next for Maria?
Well, I've written a book called Protect Your Writings, a legal guide for authors, which I think you mentioned in my bio.
Yep.
And I am almost done with the second book in the series, which will be Protect Your Photographs, a legal guide for photographers. And my goal is to have about 6 books in that series that will cover each area or each niche of intellectual property. So for architects, for software developers, for musicians, and one for each type of creative work. So,
and we didn't talk about the book that you wrote, Apple versus Samsung.
Yes. So that was just an EPUB. So that was an ebook, and that had to do with that was a fascinating lawsuit between Apple and Samsung, and all of the IP that we talked about was all covered in that case. There were trademark issues, there was trade dress issues, there was patent issues, there was all kinds of IP covered in that, copyright issues, and it was a fascinating case. But for me, it brought up the issue of how important is the free market compared to patent rights, right? So we have this tension between, as creators of content or creators of brands, we want to be protected in what we create. But the flip side of that is we also want a free market, and we want people to be able to fairly compete and to be able to do their own thing. And we don't want to quash competition, right? And it's a delicate balance. It really is. And I can see that what that tension is, and that line is not always completely clear. And in the way that Apple was enforcing its intellectual property rights, the argument was that they were really just trying to quash the competition. And I'm not saying that that's an accurate argument, but it was certainly an argument that was made. And I can see the points, but I also could see the importance of Apple having the protection over its intellectual property. So you kind of think about Tesla, for instance, who says, you know what, I'm going to create all this stuff and then I'm just going to put it out there to the world, right? So Elon Musk said, I'm going to contribute my patents to the world and let everybody use them. And he's a completely free market guy, as opposed to others that say, no, that's mine, I created it and I need to keep it. And it's an interesting debate. It's an interesting debate.
And how do you, and it's my last question, but I'm going to keep saying this is my last question. I could keep you all day. How do business owners protect their patents when they go to China to manufacture? Because obviously, China's been known to rip off patents before, right?
Yeah, very much so. So one thing I would recommend is if you do have a product that is patented here, and if you are manufacturing it in China, or if you plan to manufacture it in China, you should strongly consider getting a patent in China as well. That will give you some extra protection. There was a time when the Chinese government did not do anything to protect intellectual property, but they have really stepped up their efforts in that regard, because they recognize that it's hurting their ability to be a leader in manufacturing, because people get worried about them having their manufacturing done there. So registering the patent in China is helpful. And but most importantly is due diligence. Is using a company that you can trust, that you've gotten referrals on, that you've checked out carefully, because there are so many manufacturers in China that are, making the extra overruns and selling them on the side. And you want to make sure that the one you're dealing with is not one of those. And no matter how good your contract is only as good as the person that you're contracting with. So do your due diligence, check them out as well as you possibly can.
That's great advice.
Here's another tip. Don't do business with a ghost. I can't tell you how many times I have had litigation where the client comes to me and the person that they had the contract with, the entity that they had the contract with, either isn't a real entity at all. They didn't check to make sure it was an actual entity, or it's an actual entity, but the entity has no physical address. If they have no physical address, I can't enforce your contract. I can't find them. I'm trying to chase a ghost. So you want to make sure that when you get the address, your contract should have an address in it. And you should check that address to make sure it's a real address. It's not a P.O. box or a mailbox store, or worse yet, a completely fictitious address. Just make sure your contract is with a real entity. And I hate to say it, but if it's a foreign entity, that's even more important to check.
That's great advice. So Google map it.
Google map it. Absolutely. And look at the satellite and see the building.
When buyers give us offers on businesses, the first thing we do is Google map their address. And I can't even begin to tell you how many times it was a shack.
Absolutely. Absolutely.
And it wasn't even a business. It was a shack. And this happened a couple of times on a multi-million-dollar company. And I'm like, no, I'm not going to tell my client to sign your LOI. Show me a real business.
Exactly.
And love to get a real phone number too. Some of these corporations don't have phone numbers.
Yes, I should have mentioned that. Absolutely like correct. I agree.
Can't find a phone number for Facebook.
That's true. That is true.
All right. Well, you've been a wealth of information. Any last minute thoughts?
No, thank you for having me. This has been fun. Your questions are fantastic. Thank you.
Wonderful. Let's give your website one more time.
It's jbergwilk.com.
Okay. And we'll make sure we'll put it on our website too. So thank you, Maria. It's been an absolute pleasure. You've dropped so many golden nuggets, and I'm sure our listeners have been writing notes crazily like I have every now and then when I look down. So it's been an absolute pleasure having you here. And thank you so much to all of our listeners for joining us on another episode of Find Your Exit.
Thanks for listening to the Find Your Exit podcast. Don't forget to check out Michelle Seiler Tucker's Build to Sell Blueprint books and Exit Rich, along with more blogs, videos, and resources at findyourexit.org. Be sure to connect with Michelle on Facebook or LinkedIn and stay tuned for her next episode by subscribing in your favorite podcast player.